Win at all costs. U.S. Attorney's Office under investigation after 700 lawyers were spied on in prison. A U.S. Attorney's Office is found to have stashed hundreds of calls between inmates and lawyers. A veteran prosecutor says his old colleagues have gone rogue. A court-appointed investigator has found that the United States Attorney's Office for Kansas is in possession of hundreds of phone and video recordings of communications between attorneys and their clients, inmates at a privately run prison facility in Leavenworth. At least 700 attorneys are believed to have been recorded without their knowledge, the investigators' report submitted to a federal court said. Last week Special Master David Cohen asked to expand his probe to determine whether prosecutors regularly listened to and compiled attorney-client conversations. Already, 227 phone call recordings and at least 30 videos of attorney-client meetings have been discovered in the U.S. Attorney's Office in Kansas City. The U.S. Attorney's Office declined to comment for this story. Prosecutors obtained recordings of the conversations with the help of the private prison company that runs Leavenworth, CoreCivic, and the company that provides communications services there, Securus Technologies. Both companies have been sued several times in the past for violating the constitutional rights of inmates by recording calls between them and their attorneys. CoreCivic did not respond to multiple requests for comment. Securus did not immediately respond to a request for comment. The systematic recordings were discovered by a defense attorney who was recorded speaking with her client about the government's case against a drug ring inside the prison. Jackie Rokasek told the Daily Beast she was called to the U.S. Attorney's Office in Kansas City last August, where she said she was told by prosecutors that they had video evidence of her providing her client with confidential information about a drug ring case. Rokasek was given a computer and she watched the video. Then she says she accidentally clicked on another file. A window opened, and a video showing another attorney meeting with their client at Leavenworth played. Stunned, Rokasek immediately went to the federal public defender's office in Kansas City and told them what she'd found. Law enforcement had been listening to inmates talk to their accomplices outside the prison for months, and prosecutors had built a strong case around the evidence gained from those calls. The allegations were detailed in an April affidavit filed by the Kansas Bureau of Investigation. A drug dealer named Lorenzo Black supplied drugs to a prison guard, Anthony Iano, who smuggled the drugs into the prison and gave them to the head of the drug ring, a violent inmate named Carl Carter. The drugs would then go to another inmate, Stephen Rolette, before being distributed to paying prisoners. In the final 6 weeks of the investigation, nearly $15,000 had been deposited into Carter's account. With thousands of phone calls and a confession from Iano, law enforcement and prosecutors had more than enough evidence to file charges against Iano, Black, Carter, Rolette, and several others. Special Agent Jeff Stokes of the Kansas Bureau of Investigation filed his affidavit on April 9, 2016. U.S.A versus Black was officially underway in Judge Julie Robinson's Kansas City courtroom. It was an inmate with secondary involvement in the Black case who would soon be responsible for shifting its focus from the drug ring to the recording of attorney-client conversations. Inmate Richard Dertinger was named as a non-indicted co-conspirator in the Black case, and has been convicted for his involvement in a separate synthetic marijuana operation inside Leavenworth. During Dertinger's meeting with his attorney, Jackie Rokasek, prosecutors believed she provided him with confidential information regarding the Black case, an alleged conflict of interest that the U.S. Attorney's Office thought would force Rokasek to recuse herself from Dertinger's synthetic marijuana case. Several sources close to the Black case who spoke to the Daily Beast on the condition of anonymity said prosecutors wanted Rokasek off Dertinger's case because she is a feared lawyer. Rokasek said prosecutors planned to show her video in which she allegedly provided Dertinger with the confidential information during their meeting at Leavenworth under the belief she would recuse herself from the case. It backfired. Critics of prosecutors in the U.S. Attorney's Office say that, not only should they never have watched and listened to conversations between attorneys and their inmate clients, but that as soon as those recordings came into their possession, defense attorneys like Rokasek should have been immediately informed. Such conversations are privileged, said Peter Joy, a law professor at Washington University who testified in the August hearing that addressed the Rokasek video. "It is like a dealer at a casino having a secret camera to look at the players' cards," said Choi. "Just like that would be cheating at a casino and lead to the dealer always winning. Intruding into the confidential communications of clients and lawyers takes away the promise of a fair trial." The Black case isn't the first time that COPWATCH and Securus have been accused of violating inmates' constitutional rights. The revelation that the two companies had recorded and stored massive quantities of inmate phone calls came only after someone hacked Securus in 2015 and released 70,000 recordings to The Intercept, which found some 14,000 attorney-client conversations in the database. At Leavenworth, COPWATCH's head of security told an investigator with the Federal Public Defender's Office that cameras in meeting rooms there did not record attorney-client conversations, according to the investigator's testimony at a hearing regarding the Rokasek video. When pressed, COPWATCH eventually admitted that it had been recording attorneys and their clients in meeting rooms at Leavenworth and storing those videos for 30 days since 2008, according to an investigator with the Federal Public Defender's Office. For a 12-week period in 2016, any attorney that met with a client, even those who were not involved with the drug ring, had their meetings recorded on video, the investigator found. COPWATCH's stock was plummeting 6 months ago following a Justice Department order that called for the federal government to stop using private prisons, but the company's outlook and its stock price have been invigorated with the election of Donald Trump. The company's hopes were raised even further when Attorney General Jeff Sessions rescinded an Obama-era directive to end the use of private companies to run federal prisons. That was the icing on the cake for COPWATCH, which already saw hope for its bottom line with Trump's promises to lock up large numbers of illegal immigrants, thereby filling COPWATCH facilities, many of which house immigrants and refugees, to capacity and perhaps beyond. Accusations that COPWATCH violated inmates' constitutional rights by recording conversations with their lawyers are the mildest of allegations compared with some of the other lawsuits the company has recently been involved in. Understaffing to the point of dangerous conditions that have claimed the lives of both inmates and staff is a major theme at COPWATCH facilities. A federal jury in Idaho found COPWATCH regularly understaffed a prison there, partly resulting in a mass attempted murder in which 8 men were stabbed dozens of times by rival gang members, according to the lawsuit filed on the inmates' behalf. Incredibly, all of the inmates lived. COPWATCH wasn't required to pay any fines as a result of a judge's decision, which came down in February. As for Leavenworth, it is portrayed as a fairly lawless place in the affidavit filed by the Kansas Bureau of Investigation in the Black case. Not only was Iano smuggling drugs into the prison, he is also accused of providing a knife to Carl Carter, the leader of the drug ring. Carter is accused in the affidavit of stabbing 2 men in Leavenworth, but it isn't known if the weapon he used was the one given to him by Iano. The drug ring itself was alleged to have operated partly from a 12-step recovery program inside the prison. Despite having to pass through security to get into the area where the program's meetings were held, members of the drug ring had little trouble getting their product past guards. Informants told law enforcement that 90% of the time, when metal detectors went off, guards stopped no one, according to the Black affidavit. One guard is accused by law enforcement of purposefully turning a blind eye toward the sale of drugs, as well as their open and frequent use. "It's not an impressive facility," said a source close to the Black case. Mike Warner is not surprised about the allegations that have come out of the Black case. From 2010 to 2013, Warner was the first assistant U.S. attorney in the District of Kansas, serving directly under former U.S. Attorney Barry Grissom. What Warner saw in his time in the Kansas City office is in line with Rokasek's allegations of heavy-handed practices there. In an interview with the Daily Beast, Warner voiced strong disagreement with prosecution practices in the Kansas City office, where he said there exists a culture immune from supervision. Prosecutors are supposed to be ministers of justice, exclusively concerned with matters of fairness and due process. The polar opposite is a win-at-all-costs mentality or a self-righteous ends justifies the means approach, Warner told the Daily Beast. Further, one of the most fundamental things prosecutors must do is make sure a defendant's constitutional rights are protected. The investigation conducted by Cohen, who was appointed by Judge Robinson to conduct his investigation, has been restricted to the practice of listening to and storing recordings only as it relates to the Black case. It is now up to Robinson to decide whether to allow Cohen to expand the investigation to see if what happened in the Black case has occurred in other cases. Warren and others believe it's appropriate for Cohen to expand the probe into a pattern and practice investigation. I cannot fathom how an office acquired such a high volume of Sixth Amendment materials whether unwittingly or not, Warner said. I also cannot imagine this situation being dismissed without a full and complete investigation either by the special master or other federal investigative entity about how something like this occurred or why the U.S. attorney didn't know what was going on in his own office. In his final report, released last week, Cohen recommended continuing his investigation while noting that it would likely back up his tentative conclusion that prosecutors were not regularly viewing videos of attorney-client meetings. The most important focus of the investigation, though, would be determining how, why, and when the U.S. Attorney's Office obtained phone call recordings of inmates at Leavenworth, something that Cohen hasn't yet been asked to determine by Judge Robinson. Cohen wrote that he was optimistic that further investigation will lay to rest any suspicions on the part of defense attorneys in Kansas and the Western District of Missouri that prosecutors are playing with a stacked deck of privileged communications. Warner, however, was skeptical of the report's effectiveness at answering whether prosecutors regularly listen to attorney-client communications. For reasons unknown, the report also ignored the deliberate use of those materials against Rokasek, Warner said. Nonetheless, I'm hopeful the special master will continue his investigation as alluded in the report's conclusion. Maybe then widely reported abusive practices will actually be addressed.
Hey Charlotte County, this is Charlotte County COPWATCH, and I wanted to explain what fair use is. You can use pieces of news articles if you're doing it for news reporting, you have commentary, and you're doing it for education purposes. So that's what fair use is, as you can see right here. Another reason why I wanted to make this video is to let you know I have just joined with Patreon. A nice thing with Patreon, I make no money on YouTube. They took the money away years ago, and so this is another way to give, and it's a nice thing too because you can give monthly. You can give $1, $5, $10, whatever. I do 4 to 5 hours a day on trying to wake the sheeple up on how corrupt it is and different ways that you can fight the corruption. So Patreon is a way that you can do it, and then of course the old way is still there. Donate to Charlotte County COPWATCH with PayPal or credit card. So keep that in mind. 4 to 5 hours a day. I make no money, but the corruption happened to me and I'm sick of it, so I'm trying to wake people up. But my wife would love it if if we could get some help out there. There's 47,000 subscribers. Just think if each one of you subscribers just gave let's say actually yes, $1 a month. 47,000 subscribers gave $1 a month. That would be awesome. That's not going to happen. But anyways, that would be great if it did happen. But do the math in your head. Just think about it. Like I said, 4 to 5 hours a day. I get no money from YouTube. YouTube has gone nuts. You can't do anything anymore. They're taking the money away everywhere. So these are a couple different ways that you can still help out with all this time that I put in. And as you know, I'm in a special situation where at least I can do it. 4 to 5 hours a day. We have a cleaning company during the day. That's what allows me to do this, and we're debt free. So this is my hobby. I don't go fishing and all that other crap. I try to save the world. So help me out to make the wife happy, man. In fact, if you guys did give $1 a day, and there was 47,000 of you, and you did it, and each of you gave $1, and that was every month, oh my God, yes, I could quit. I could start suing them. Another idea too that we have is, if I got, you know, some funds, we could actually contact everyone that has been ticketed and or arrested and put in jail and start sending them postcards to let them know we're here and to see if everything went all right, and if it didn't, find out their story. So we could even do more investigations and more lawsuits. Lawsuits take money. So just think about that. You know, 47,000 of you so far right now. You know, $1 a day. I mean, $1 a month on Patreon, or $5 a month Patreon, 10, 20, whatever. Just do the math in your head. Help out. This is a lot of work every single day. Thanks.